Frequently asked questions about California end of session items. The first one is how many times can a bill be reconsidered? Regarding reconsideration of bills, the same rule applies whether a bill is in committee or on the floors of the Assembly or Senate. And the rule is that only one reconsideration is in order. So the first time a bill fails, it can be granted reconsideration. However, if it fails a second time, that's it. There's not a second reconsideration, and as a result, the bill has failed passage if it fails a second time after having been reconsidered. How many times can a bill be placed on call? Well, there's no rule on this. In other words, the joint rules, Senate rules, and Assembly rules actually don't cover the number of times a bill can be placed on call, whether it's in committee or on the floor of either the Senate or Assembly. This question is also not covered in Mason's manual. The rules of the two houses state that the call is continued by a majority vote of the members present. That's all that's stated. What exactly is the 72-hour in print rule? A bill cannot be passed or become a statute unless that bill and any amendments have been in print and published on the internet for at least 72 hours before the vote. The only exception is if the governor has submitted a statement that the bill is needed to address a stated public emergency. As a result, with, for example, a mid September adjournment date, bills would have to be in their final form by midnight, 72 hours earlier. What is the consent calendar? Now, there are different rules between the Senate and Assembly regarding what is a measure for the consent calendar on their respective floors. For example, under Senate Rule 28.3A, if a Senate bill or Assembly bill is amended in the Senate to create a new bill or to rewrite the bill, then a standing committee is prohibited from placing that bill on its consent calendar. There's also a special consent calendar used on the Senate floor, as well as occasionally the batching of bills on the Assembly floor. What's the inactive file? Bills taken off of the Senate inactive file are returned to the second reading file, but in the Assembly, bills previously on third reading that were moved to the inactive file are subject to a 1 calendar day notice when removed from the inactive file, and they're returned to the third reading file. So that's how the inactive file and return to the regular file is handled in the two houses. Can policy committees meet during the last 2 weeks of the legislative session? Well, with a rule waiver, committees can meet during this time period. However, under Senate Rule 29.10, 2910, and Assembly Rule 77.2, these deal with bills that have been substantially amended in the other house, and they're referred back to a policy committee hearing, and those committee hearings are actually not subject to a prohibition on committees meeting during the final 2 weeks of session. What about double jointing amendments? Well, double jointing amendments are amendments to a bill providing that the amended bill does not override the provisions of another bill where both bills propose to amend the same code section of law. And double jointing amendments are used to prevent, the problem of chaptering out of the earlier enacted version. What's a contingent enactment amendment? Contingent enactment means that there's a section in the bill that indicates it is to become operative only upon the enactment of a certain thing to happen or the enactment of another measure. So its enactment is contingent upon something else happening. Are there limits on the number of floor amendments? There are some limitations to making floor amendments. For example, Assembly Rule 69 says that a motion to amend on the floor is not in order during the last 7 days before either the interim recess in the first year or the odd numbered year, or in the last 7 days prior to the final recess that occurs in the second even numbered year. Now, that rule can be suspended, but it requires a 2/3 majority vote of the House. This rule does not apply to adding or deleting an urgency clause or adopting so-called double jointing amendments. What does concur or non-concur voting mean? Under Joint Rule 26.5, a motion to concur or to not concur is not in order until the Legislative Council's digest has appeared in the daily file. However, the motion is in order even if the digest has yet to be printed, so long as an analysis of the bill has been prepared and distributed to members of the floor on the floors. Now, this is generally done by having the analyses either on their laptop computers or at their desk in a physical form. The additional note is that the rule can be suspended by a majority vote of the House's members. How do Senate and Assembly floor analyses differ? The Senate floor analyses list support and opposition positions, while the Assembly version does not list any publicly stated positions on their floor analyses. Can vote changes be made in either house? The Assembly allows its members to add or change votes after a vote has been announced, so long as the final vote is not impacted. The Senate doesn't allow this, except for the President pro tempore and the Republican leader, as long as the final outcome of the bill is not affected. And this you can see in Senate Rule 44. What's a so-called point of personal privilege? A point of personal privilege is defined to be an assertion by a member that his or her rights, reputation, or conduct have somehow been impugned, entitling that member to stand and repudiate the allegations. What's a parliamentary inquiry? That is a procedural question that's posed to the presiding officer by a legislator during a committee hearing or a floor session regarding one of the rules applicable to that instance. Is an adjournment motion always in order? In the California Legislature, an adjournment motion is not in order if a bill is still on call. You can see this in, for example, Senate Rule 42. Now, once that call has been lifted, then a motion to adjourn can be made. When can budget trailer bills be enacted? Basically, they can pretty much be enacted anytime after the budget bill has passed. So long as there's some nominal appropriation to the bill and it's tied by language to the budget bill, and the trailer bill number is listed in the main budget bill. This can also be done by a majority vote on each floor of the Assembly and the Senate. What does pass on file mean? A bill author may choose to pass on file, which temporarily gives up their opportunity to take up their particular measure on the floor of the Assembly or the Senate. How about the term or the phrase pass and retain? Well, in the Assembly, pass and retain precludes the author from taking up the bill for that legislative day. However, the Senate doesn't recognize a difference between a pass on file and a pass and retain. And finally, why are letters to the Daily Journal used? Well, these letters to the Daily Journal are generally used to express legislative intent or explain the purpose of a bill. And they're published in the journal in usually the bill's house of origin that particular day that the motion was adopted by at least a majority vote. These letters are supposed to be signed by the bill's author, and they're approved by both the majority and minority leaders in that house as a general rule. Now, to be fair, if there are objections, it's like a normal motion, and the letter can be printed with a majority vote of the body choosing to do so. So those are sort of a handful of end of session items that often questions are raised about how they operate, particularly at the end of the California legislative session.